Hi, everyone.
Hi, Wei.
Good morning.
You are in the trademark and copyright room. um, I hope to be able to share some of my knowledge with you. This has been a very inspiring morning already, and now we change gears and get into something a little bit more specific about perhaps an area that you have to deal with as a business owner and entrepreneur. Again, for my intro, I have a computer engineering background as well as, so I deal with patents a lot, but trademark is also a very important area of practice for me. So it's kind of a left brain, right brain kind of thing for me. All right, so my firm is we have about 40 lawyers. We are a virtual firm. That means we don't have real estate. We don't lease an office space. So, and we don't have employees. So we have one. So we're able to keep our billing rates down. Most of our lawyers are former big law partners or in-house general counsels, but we have found that this is the best way to practice law. Happy lawyers, happy clients. So, all right, and most of you may already have some foundational knowledge about trademarks, but I hope you can learn something new today. So a trademark can be almost anything. It can be one word or multiple words. It can be a symbol or what we call device. So it can be shape of a package, color of a package, even a smell or sound or a motion. So it can be a very broad, uh, different kind of things that businesses can use to identify themselves. So these trademarks are used to identify the source of goods or services, and companies, by using their trademarks consistently in the marketplace to promote their goods and services, they collect goodwill and reputation associated with their goods and services. Trademarks is a right that businesses have as soon as the trademark is used. So it can be born when you start using a trademark. But we will talk about a little bit later the differences between common law trademark and federal registration when you have a federal trademark. And most business owners know trademarks can be your most valuable asset when you transfer. A lot of times when you sell and buy businesses, you want to buy or acquire that the trademark rights that the previous owner has already, or previous business has already collected behind that trademark. Here are some examples of very well-known trademarks. And as you can see, these are either logos, designs, or words. And Tiffany blue is the color itself. And the Coca-Cola bottles are examples of packaging. The shape of the package can also be a trademark. When we see a Coca-Cola bottle, we don't even have to look at the words or the symbols that's on it. We know it's a Coca-Cola bottle. Okay, so those are all different types of trademarks. I have also, and these are kind of rare, I have also successfully registered a smell for a client. Smell for a sandal, actually. The smell is a tropical coconut smell. When you open the package, when you receive the shoe, there's a tropical coconut smell that you then associate with their shoe. So I think it's a very effective marketing. What are some common problems or issues that come up with trademarks? One common thing that I see is, for various reasons, the business do not do proper searches before they start using a trademark, or they come up with the trademark and that they're in love so much, and they just start using it without consulting with the trademark lawyer. Also, trademarks, a lot of times what I see, and big companies do this also, they use them improperly. The danger of using trademarks improperly is the trademark themselves become generic. And that's almost like suicide for trademarks. Common examples are Xerox. You know, it was approaching the point of being becoming generic, because when people say I'm going to Xerox Xerox this document, uh, when they should have been saying, I want to make a copy of this document. When your trademark becomes a generic term, then that trademark is no longer being associated with a particular business, and that then you lose all of the utility function of that trademark. So I'm going to touch on a little bit on proper usage of trademarks. And I've also seen confusion between trademarks and copyright. So the C circle symbol is really the proper symbol for copyright notice, not trademark notice. So we'll touch on that a little bit as well. Why do you want to search before using a trademark? Well, you don't want to start using a trademark, start branding with your trademark, putting it on letterheads and business cards, on your website, buying URLs, domain names with your new trademark, and then have somebody, a lawyer, send you a cease and desist letter accusing you of infringement of another company's trademark. It's very costly to rebrand, and it's very costly to be sued and defend yourself in court. And also, you may incur liability because economically, because if you're not successful in defending your trademark infringement lawsuit. So as lawyers, trademark lawyers, we want to keep you out of court. We want to make sure that you pick the right trademarks and that you can sleep at night knowing that your trademark your trademark usage won't infringe someone else's trademark. I just want to touch on some fun trademark infringement examples, so just to let you know, it's a very active area of litigation. And as you can see, the trademarks don't have to be identical. They can just be similar. So when you look at them, it elicits memory of another company's trademark. Here's a D-Dog with the bones. 3 bones was accused of trademark infringement by Adidas. Here, Adidas has trademarked the 3 stripes on the sneaker. So Skechers was accused of infringement. So the sneaker can look entirely different, but because of the 3 stripes, they were in danger of trademark infringement. Gucci and Guess were in litigation over the design of this sneaker. Again, they're not the same, but you can see that consumers would have confusion when they look at these two and they can't figure out which sneaker came from what company, what designer. And this is a fairly famous example where Christian Louboutin sued Yves Saint Laurent for the red sole. Christian Louboutin actually lost that lawsuit, unfortunately. When women see the red sole, we automatically think of Christian Louboutin, but they actually lost that lawsuit. Starbucks is another company that's very zealous in going after other companies that use trademarks that are similar to their trademark, very famous mark. And you can see that these two marks are totally different, but because of the similar color scheme, they were sued, and I don't know what the result was that was in that case, but you don't want to be sued, even if you end up winning, right? Because then you have to spend money to hire lawyers to defend yourself. Here are more examples. Anytime you're using a trademark that makes the common consumer in thinking about another company's products or services or their trademark, then you want to rethink the choice of your trademark. Buc-ee's is a familiar roadside sign that you would see when you are traveling on, especially in Texas. But they are very, very much an 800-pound gorilla when it comes to protecting their trademarks. They sued Choke Canyon Travel Center, which their trademark featured an alligator on a yellow background. So Buc-ee's sued them because there's a yellow background and then there's a cartoon character. It doesn't matter, it's a totally different character. They sued, and once they are sued, most of these companies were just, forced to rebrand. They couldn't continue down the path of litigation. So because Buc-ee's can't afford to hire lawyers and make you stop. Um, so be very careful in how you pick your trademarks. Here's some other ones: Herbs R Us versus Toys R Us, In-N-Out and In-N-Out dry cleaners. So for all my clients, I want them to pick unique trademarks. And we'll talk about what that means. And you always want to hire a trademark lawyer to search for potential conflicts, because they will keep you out of court. They will keep you away from the receiving end of cease and desist letters, and help you strengthen your trademark. And your trademark should not be confusingly similar to an existing trademark. They can't sound alike and they cannot look alike. So what do I mean by picking a unique trademark? Here we have a spectrum. On the left side is what we call generic. And on the far right is fanciful and arbitrary. So what do I mean by generic and descriptive? So generic could be purple milk, that trademark for a dairy-based drink. So you're essentially calling something exactly what it is, right? So you cannot have a monopoly of banana, calling it banana and using that as the name for bananas, right? So it's kind of common sense that you should not be given a monopoly for that trademark, because other merchants that sell bananas should be able to use the generic term to refer to their product. So what is descriptive? For an example of bright for flashlight. So it is a trademark that describes some characteristic of the goods and services. So that is also a weak trademark, and we try to persuade our clients not to choose trademarks that are descriptive. It's more difficult to get it registered on the federal registry if your trademark is descriptive. What are suggestive trademarks? For example, Oasis for cold beverages, right? It promotes some imagery in your mind, but it's not exactly descriptive. Fanciful, Xerox, Cisco, Microsoft. These are made up words that have been coined or put together. You know, Microsoft could be microcomputer and software put together to come up with a new word. So these are fanciful marks that are strong in terms of trademark the strength and are this type of trademark is strongly encouraged. What is an arbitrary trademark? Arbitrary trademark is using an existing word or term for product and services that is not normally associated with that word or term. An example is Apple for computers, BlackBerry for mobile telephones, Gap for clothing. Okay, so we generally want your trademark to be on the right side, right end of that spectrum, to be either suggestive, fanciful, or arbitrary. Okay, here's a little bit of information on the two types of trademark rights. In the United States, we have what is called common law rights, and we also have a parallel system that's for federal registration, federally registered trademarks. What does it mean by common law rights? Common law rights, trademark rights are born, like I said before, as soon as you start to use a trademark. So as soon as you start to market your product using a trademark, that trademark is born. Now, what does that mean? If when I use that trademark only within Texas, my customers are only in Texas, I only advertise in Texas, that means the footprint of my trademark rights for that trademark is only Texas. Okay, so it's based on actual use. And versus when you have a federal registration, your trademark is presumed to be nationwide in scope, okay, the entire country, even though you may operate only within Texas and Oklahoma, for example. It has to be interstate commerce happening because it is a federal trademark. So when interstate commerce happens, when you are, for example, you have a website and you are able to sell goods and services over the website. You advertise on the website. You use social media that is national in scope. Those all are things, activities that you do as a business owner to use that trademark that gives you the ability to register your trademark on the federal registry. So for federal registration, you can apply for that trademark after you have started using that trademark, or you haven't yet used the trademark, but you intend to use that trademark down the road, but you want to start locking it down right now by filing an application. And that's highly encouraged. As long as you have a bona fide intent to use a trademark, let's get it locked down. Let's file that trademark application now rather than when you get your ducks in order and have started actually using it, because we don't want somebody to, for example, you secure a domain name and people may watch those kind of activity and they say, oh, this company is going to use this domain name, this trademark as their trademark. I'm going to get ahead of them and register that trademark. So you don't want that to happen, right? So the steps is file your trademark application, then go secure your domain name. Now, your priority for that trademark then is based on your filing rather than when you start using the trademark. So it gives you an advantage of getting there, getting to the trademark office ahead of other people. So trademark, when you use trademarks, you want to give notification to other companies that this is your trademark, do not use it. This is my exclusive right. So how do you do that? So when you see the letters TM, that means this trademark is being used, but there is not yet, or sometimes companies don't obtain federal registration. But when you see the circle R symbol, that means it's a federally registered trademark. Okay, so you should use these trademarks notices properly. So if you don't intend to apply for federal registration, or you may want to, if you want to do that a little bit further down the road, go ahead and put the TM on your trademarks. All right, and that is just notice to other third parties that that is your trademark. Do not come near it. Do not use it. This is mine. So why do you want to register your trademark? We talked about it a little bit earlier. It gives you a nationwide footprint, right? It's presumed a valid trademark, and it's presumed that you own it. Those are all really big advantages when you ever have to sue in court. Those are elements that you can establish easily with your federal registration. And it's also a public notice of ownership. Your trademark registration is in the trademark in the federal database. When companies are doing their searches for available trademarks, that's where they go to search. So if you are in there, your registration is there, they understand, oh, I should not pick a trademark that's similar to this company's trademark because they already have something that's very similar. Also, if you deal with products that are generally imported into the US, you can register with the US Customs and Border Protection. Here's my registered trademark. Please stop all counterfeit products that come into the United States. And you work with them to stop all those infringing products so they don't come into the US. All right, so that gives you a huge leg up in terms of enforcement. Having a federal registration also gives you the ability to sue infringers in federal court. Otherwise, you have to sue in state courts, and if the infringements happen, infringers are in different states transacting business, then you have to sue them in different states. So that is definitely a disadvantage with that. Here's some common mistakes or misunderstandings. When you obtain a domain name, that is not the same as obtaining a federal registration for your trademark. So it's not the same. And in fact, I encourage you to apply for the trademark first and then obtain the domain name, just so that other people don't get ahead of you at the trademark office. And also obtaining a state business name registration is also not the same as a federal trademark registration. When you go to the Secretary of State at a state and you look up to see availability of business names, that is, they're not connected. Those databases are not connected to the federal trademark database. So the searches do not produce the same results. And what they're looking at there is looking at availability of business names, which is not exactly the same as trademark registration at the federal level. So please keep that in mind when you are picking trademarks and trying to come up with ways to protect your trademark. All right, here we touch on trademark usage because it's so important to make sure that your trademark has longevity, because your trademark can last as long as you are using it. If it's a federally registered trademark, you do have to pay renewal fees, but as long as you're keeping it up, unlike patents, a patent is only good for 20 years. Trademarks can last as long as you're using that trademark. And for federal registration, as long as you're renewing and using the trademark. So what does that mean? What does it mean to use your trademark properly? So when you look at a promotional material on website and a brochure, for example, you need to use different font, different color, different type to set your trademark apart from the surrounding text. So it is most prominent, more prominent than all the other text that's on that page, um, so that people can zero in on what it is that you're calling your goods or services. And of course, logos is a little bit easier, right? We want to make sure your logo is closely associated with your product, either it's on the package or on all the promotional materials. But for the word marks, you also don't want to use it as anything other than an adjective, and we'll talk about examples later. We should not use it as a noun or a verb, and we don't want to use it in a plural form or use it in the possessive. Okay, so all of these things can weaken the strength of your trademark if you use it, if you don't follow these guidelines. So what do I mean by this? So on the left hand side column, try not to say by Tide, right? So here Tide is being used as a noun, but instead we want to say by Tide detergent. We don't want to use it in a possessive form, Tide's whitening power. We want to say the whitening power of Tide detergent. We don't want to say Xerox's report using it as a verb. We want to say make a copy on the Xerox copier, or make a copy use, well, maybe there's not another better alternative, but avoid using the trademark as a verb. And also the last example, don't use trademark in as a plural form. These are all the left-hand side, the no-nos will strengthen your trademark if consumers keep using it that way. Your trademark will no longer be associated with a particular company and a particular product, and it will become generic. Now, we'll switch gears a little bit on talking about copyright. So trademarks and copyright sometimes get confused. So copyright actually is a very different type of intellectual property. It is used to protect a work of authorship. So what do we mean by that? It means that it could include photographs, drawings, paintings, song lyrics, music recordings, videos, movies, literary text, computer software code, the way a screen is laid out, user manuals. Those are all examples of something that can be copyrighted. These are all works of authorship. So what is the requirement of a work of authorship that can be granted copyright, two requirements. It has to be fixed in a tangible medium, meaning it has been written down, it has been drawn, painted, created, or recorded. So it's no longer just some intangible concept in your head, but is now in a form that has captured it and fixed in some way. And also, it has to be original. It cannot be something that you copied from somebody else. It has to come from your head, something that's original that you have created. Um, what does copyright give you when you say copyright? So copyright is what we call a bundle of rights. It gives you multiple different types of rights with regard to this work of authorship. You can make a copy, you can create a derivative work, meaning make a copy of it and then modify it in some way. Uh, Selling it, distributing it, transmit copies, perform it in public, or display it in public. So each of these type of rights can be separately licensed or separately transferred. So for example, if I have a painting, I made a painting, I can sell the physical painting, yet retain the copyright to that painting. So the buyer of that painting now has the physical painting, but if I don't also sell the right to make copies, make derivative works, or transmit it in electronic form, then all the buyer has bought is just a physical copy. They can hang it in their house, and that's it. Okay, and I, as the author, I can retain some of those rights and still make additional revenue from those other rights. So copyright can be a very powerful way to give authors and creators way to create revenue stream from what they have created. Um, so there's a common misconception um, about who owns by default a work of authorship, who owns that copyright. So one scenario is a company employee creates a design for your company. Who owns that? Who owns the design? Who owns the physical thing that the employee has created? In this case, the company owns the design and the copyright for that design. How about when you hire a contractor? So a contractor who is not an employee made a design. Who owns that? The company owns a copy of that design, but not the underlying copyright of the design. Okay, so it is very important, if you intended when you hire a contractor to own, when the company intend to own, I pay you money, you create this for me, and I want to own everything, then you need to have a written agreement that spells the ownership out. If you don't have an agreement in writing, then by default, the contractor owns that underlying copyright. Okay, it's a very important concept that you have to keep in mind, um, because nowadays we hire contractors to do all sorts of stuff. We ask them to design websites, we ask them to come up with designs, we ask them to create logos for us, all sorts of things that your business uses. So be very careful. You must have a written agreement with each and every one of them that spells out the ownership of the copyright. Okay.
I'm so sorry to interrupt, but we are ending in about 5 minutes.
Okay. Got it.
So,
I'm
all
almost
right. So, if
done, I
anybody
think.
has any questions, just type it into the chat, and I'll be happy to read it out to Miss Jeang. And that's about it. Sorry.
Okay.
Go ahead.
No, that's great. So by default, the author is the employee in an employee scenario. By default, the author is an independent contractor, and the author owns that copyright. So you must have a written agreement. And I see this all the time with clients coming to me. Hey, I received a cease and desist letter accusing me of copyright infringement. What we used, what we thought is something that that can be freely used. So be very careful about these types of pitfalls. You really need to document where you obtained any kind of design that you incorporate into your materials, especially into your website. Make sure, if you use Creative Commons licensed images and images like that from some public domain. If it's not truly public domain, we really need to read the fine print, because when people see, oh, it's Creative Commons, it's free, but if you don't follow the requirements exactly, they have the right to come after you. And we see that again and again and again. Clients receiving cease and desist letters because of the Creative Commons license no-nos. And you can be potentially liable for up to 150,000 per violation. I think that's probably good. You can federally register copyright, and it's very simple process to do that. So I want to leave a little bit of time for questions.
Does anybody have any questions for her? No?
Nope. We're all good. Feel free to just send me a note if
there is one. How
okay.
much to copyright and timeline?
Copyright is there's a $45 filing fee. And if you use their online form, and it's a simple form, timeline wise, I want to say maybe 6 months. So it's fairly easy to do. But sometimes it's not that straightforward. So, read up on it. If you all have any questions, feel free to just send me a note. Be happy to just talk to you.
And I can share her information with anybody who would love it. I can share Miss Jeang's information so that you may contact her at your earliest convenience. Thank you so much, Wei Wei. We really appreciate it. You covered a lot of stuff in that short period of time.
Yes. Thank you all.
I never would have thought to think of the one with the alligator. Because I did stop at that gas station, and that was the first thing I thought in my head was it looks a little bit like the Buc-ee's sign, even though it was like two different, completely different ones, but just the similarity. That was the first thing that popped into my head. So
yes.
It wasn't as good as Buc-ee's though. So the bathrooms in that one were very dark. So that's why when I saw that, I was like, oh my gosh, I went to that once. But they have good barbecue at that one.
Oh,
perfect.
All right. Thank you for having me.
Thank you very much, Wei Wei, for taking time out of your busy schedule to be with us today. And thank you to all that participated in this breakout session. If you have any questions, you can either reach out to me and Rowena, but I'll also be happy to share Weiwei's contact information if you would like to hire her to kind of pick her brain a little bit more on copyright infringements, or if you have something you want to copyright, you could talk to Weiwei about it. And then just a reminder, when you guys hit the you guys have to hit the leave room button and not leave meeting button, because if you hit the leave meeting room button, it'll completely kick you out of this Zoom meeting. So the leave room button is actually going to appear. Let me see. We have here, let's see. Louise, can you tell us where the leave room button is?
Right side. It's actually on the right side.
And it's blue color.
Yeah.
Yeah. All righty.